Welcome to our podcast. I'm Diana Bromberg.
And I'm Nicole Henriquez.
And we are the attorneys of Bromberg and Henriquez PC. We're located in Queens, Bayside, and in Long Island and Garden City, but we have availability in all 5 boroughs and Long Island, so we travel to you. One of the topics that we'd like to discuss today is settlements. And settlements come in many different forms in a workers' compensation case, so we're going to touch on the major ones today for you to give you an idea as to what needs to happen. So if we'll discuss the scheduled loss of use.
Sure. Okay, so if you've been injured at work, you're entitled to lost wages. But after you've done your treatment and your doctor has indicated that you're at maximum medical improvement, which means that you're done with your physical therapy, injection, surgery, usually about 8 months after that surgery, they will determine whether or not you have a permanent injury. You could be back to work. So for instance, if you injured your shoulder or you broke your arm, and you went back to work the next day. Let's say you have a great boss that says, come back with that cast, right? You go back to work. After you're done with your treatment and your doctor feels as if you have reached maximum medical improvement, the doctor can indicate that in a scheduled loss of use report. What is a scheduled loss of use report? That is based upon the loss of range of motion of, let's say, your elbow. So we've had several clients who've unfortunately broken their elbow. After that, there is some type of residual or some type of leftover permanency to that elbow. So for instance, if this elbow that you broke or that you tore a ligament in, you can only move this much, but this elbow you can do everything with, this loss of function is worth money. So hypothetically, if it's worth 30, 40, 50,000, they will deduct what they previously paid you. So prior to getting the final settlement, they'll review and say, okay, we paid this person $10,000, but this broken loss of function, broken arm, torn ligament is worth $50,000. At the end of the case, you get the $40,000. But let's say if you never lost a day from work and you worked the whole time with your cast and you went to physical therapy and they never paid you anything, you would get the full $50,000 at the end of the case. Obviously, if you hire us as an attorney, there would be a deduction for any attorney's fees, which will be set by the judge. However, this is what you're entitled to. There is no pain and suffering in workers' compensation. It is just for the loss of function of that elbow, or if you tore your shoulder, or if you tore your, wrist, or your knee. Unfortunately, this type of award is not given for your head, your neck, or your back. That's a different type that Diana's going to talk about. But for scheduled loss of use, this is the award that you can get.
So just to kind of define it for people, it's a loss of a limb, loss of use to a limb. You don't have to actually lose your limb. You can keep your arms and your legs, please. But if there is a loss of use to any of your limbs, then you would be entitled to what's called the scheduled loss of use. So the other type of settlements that you can be entitled to is called permanent partial disability, could be also permanent total disability. And this applies to people whose condition becomes such that it's either impossible for them to go back to work, or if they do go back to work, they're making less money. So they would be classified with permanent disabilities that prevent them from working their full capacity or working at all. And those usually include your head, your neck, your back. It could be a psychological condition. It could be a multiple of conditions that usually encompass a person's inability to return to their gainful employment status. And in those cases, depending on what degree of disability you have, you're entitled to get a certain amount of payments per week for a certain amount of years. They used to have where your benefits were not capped, where you can get this $200, $300, $400 a week for the rest of your life, but they did change the law, and the law now says that you would be capped at a certain amount of time unless you were found to have a permanent total disability, or your percentage of loss of wage earning capacity, which is the term that is used, is above a 76%. So we are very, very diligent in making sure that we get the percentage to such a degree that you maximize in the weekly benefits that you're receiving, how long you're going to receive those benefits, and try to help to make sure that you are compensated for your inability to make the same living that you did prior to the accident.
Just to add on that, in terms of, I'm sure you heard Diana say that prior there was lifetime benefits at maximum $400. But in 2007, that law changed. So when that happened, in exchange for giving a cap, a shortened period of time that you're entitled to this money, they increased the compensation rate. So at this time, people can be getting $870.61 per week versus what they used to get, $400. Of course, that's dependent on how much money you used to make. If you only used to make a lower amount, you wouldn't be entitled to the maximum. It is still 2/3 of your salary, but we're getting off topic. But I do have one other issue I wanted to raise because Diana brought up a good point. She indicated that with psychological claims, they can be included in a permanent partial disability. And I know most people don't even realize that psychological claims would even be considered in this type of case. Unfortunately, when you're out of work for many years, or if you have chronic pain, many times people become depressed, they become anxious, and this is called a consequential claim. What does that mean? As a consequence of your injuries and your disability, you have now become depressed. We fight to get those included in your case because you're entitled to treatment for that. Why shouldn't you get it? If it wasn't for this accident at work, you wouldn't be here. You wouldn't be here suffering with depression or anxiety. And also, just to add to that, there are other ways that you possibly could have consequential claims, and the insurance companies won't tell you that. For example, if you have a torn knee, you've had surgery, or even without surgery, but because of it, you are now walking down the street and your knee buckles, the knee that is injured in this case. Because it buckles, you fall and you break your arm. That is as a consequence of that knee. You would not have broken your arm unless your knee buckled. We fight to get that as part of your case.
Right, and what's important to understand why the additional sites of injuries are important to bring into your case, because they all go into determining what is your loss of wage earning capacity and to determine how long you would be entitled to receive your benefits. So we're not going to try to have you fall, but if it does happen, we want to make sure that you're protected and that those sites of injuries are included in your case and gives you the ability to receive benefits longer. So the other area that we'd like to talk about in terms of settlements is what's called a Section 32. And this is basically the only way where your case gets closed. So a lot of times you will hear from the insurance companies, from the doctor's offices, that your case is closed. There's only one way to close your case in a workers' compensation, and that is a full and final Section 32, which has to be approved by a law judge. You have 10 days in which you can change your mind, and when you don't change your mind after 10 days, it becomes permanent and final. If you did not hear that language in anything that you've signed or been given in court, your case is not closed. So I'll have Nicole talk a little bit about the Section 32s. There are two different types and why one is, sometimes better than the other.
Just to add on to that, that's just like one of my biggest pet peeves, I'm sorry. But when, people have had injuries, let's say they haven't had active treatment for 5 or 6 years, and then all of a sudden their injuries become worse over time, no new accident, but just their injury got worse, and they call the insurance company, and sometimes the insurance companies say, I'm sorry, your case is closed. That is a pet peeve because that's not true. Like you're basically misrepresenting and pressuring this injured person from pursuing what they are rightly entitled to. So I had to say that, I'm sorry. But, in terms of, Section 32s, we do have a system in our office that we try and streamline things. I am in charge of the Section 32s, me and my assistant, Carolina. We take very much care in determining what the overall picture, the lump sum money you would be entitled to. We take that weekly payment that you're getting on that permanent partial disability, or even before you become permanent. We can speak with the insurance company and see if they're willing to buy you out in a lump sum. So let's say if your weekly rate is $700 a week and you could be entitled to this for the next 300 weeks, you could get $210,000 if you are still out of work on a weekly basis. They're not going to give you $210 because they can just wait and pay you on a weekly basis, right? So what we do is we negotiate with them to see, out of that $210, how much can we get today? Because the present day value of the money is different than the future value. And this is how we negotiate. Additionally,
I'm just going to jump in for a second because I know one of the biggest questions we get from our clients regarding the Section 32s is why should I take a lump sum or a buyout of my case? And we always say that it's very case specific because there are some people who would like to take the money today and use it as they feel is important for them. Financially, this is what works for them. And there's some people who actually prefer to get their benefits every 2 weeks for as long as their benefit lasts. So while it is case specific, we do sit down with you and we go over the options and we explain to you why maybe in your circumstance it's better to take the lump sum, or why it may not be a good idea for you to take the lump sum. So the other part of this 32 is that you can have the case bought out fully, which means that they take and buy out your weekly benefits as well as your medical, or you have the option of taking the weekly benefits to be bought out, but you leave your medical open so that if you did need surgery in the future or you needed some kind of treatment, it would be covered. So there are two different ways to approach it, and we sit down with you to make sure that you understand what you are able to do, what you're giving up, what you're keeping, and that you make a decision that is best for you, for your family, and not just about the dollar and cents.
And that's exactly what I wanted to say, because Section 32 is you're closing out everything. But if we see that someone's had a back surgery and it's failed, meaning they really are not doing well after this back surgery, we have clients coming to us every single day saying, look, I want the maximum. I don't care if I close out my medical. I just want to get rid of this case. And we have to sit there and say, look, you're doing this against our advice. We would not advise you to do this, although it would give them more money and essentially give us more money in a fee. But we don't look at our clients as just a dollars and cents. We want to give you the best evidence as if we're talking to someone in our family. We want to say to you, think about 10 years down the line. If you need surgery, who's going to pay for it? This money may last for now, but it may not last forever. So we try and take a holistic approach in how we review things with our clients, and then they give us the best, answer that is best for them. In terms of the indemnity, a little bit less than the Section 32, but your treatment would remain open. So you could still be entitled to the same treatment that you got prior to the indemnity only. You could still be entitled to everything you were entitled to in terms of the treatment aspect, but not the money aspect.
Right, and why it's important is because if you close out your medical and 3 months, 3 years, 10 years later, you need some kind of a treatment. If the doctor feels that your treatment is in any way related to your workers' compensation case, there is no insurance company that will pay for it. That means that it's your responsibility. And when it's your responsibility, you have to come up with that money out of pocket. And we all know that medical bills can be very expensive. So before making a decision to settle your case with a Section 32, we outline it for you, we explain it to you, and we make sure that you understand what you're accepting and what you're giving up.
And just to add to that, the court even puts in another 10 days after your settlement hearing. This is the moment where you can back out in writing.
Yeah.
They give you that extra 10 days after you've already gone to the settlement hearing. That's how serious it is. And we take it that seriously in our office.
Yes.
And lastly, you want us to talk about facial disfigurements?
Yeah, so sometimes, in an accident or an injury, you can get facial disfigurement, which means you can get a scar. We've had cases where someone lost an eye, which they were able to receive benefits. Someone, got a gash on their face. Usually the scar has to be visible and it has to be permanent. So if you got punched in the face and you cut your lip, but your lip healed and you can't see anything, you're not going to get a settlement. And while it is a situation where the judge has to agree and the insurance company has to agree, we do try to maximize that by getting your pictures before your accident, how you look after your accident. Are you in the public? How does this facial disfigurement affect you? It is not a unlimited number, so there is a limited number. The most anyone can receive for a facial disfigurement is $20,000. So unfortunately, even if you do lose an eye, which we had a case where the person lost their eye, they were receiving the $20,000 for the facial disfigurement. However, in that case, because they lost their eye, they were also able to get a scheduled loss of use,
right? That was
which
the
we
other
didn't
topic.
mention,
Right.
which is the loss of hearing or loss of vision, which is another topic that we'll discuss at another podcast.
And I just wanted to add that even with these permanency findings in court, whether you're permanent partial, permanent total disability, or scheduled loss of use, if you're under the age of 25, you could be entitled to additional benefits. So please give us a call at 718-714-8542. We can explain to you what that additional benefit is because you're under the age of 25.
So thank you for coming to and listening to our podcast. We appreciate your attention. I'm Diana Bromberg.
And I'm Nicole Henriquez.
And we look forward to speaking to you regarding your case.
Thank you.